Hi, this is Jeff Fowler with the Apartment Owners Association. It's great to have you with us today, and we're bringing you just another update and about the LA County moratorium, what you need to do, probably we're going to be talking about the different forms that you have to use when you're trying to serve eviction papers. We're going to talk about the tenant protections. And so before we get started, AOA, we've been around for over 40 years, and we're the largest individually organized group of apartment owners here in the state of California, and our goal is your success. We want to help you make things easier and more enjoyable as you're managing property. And although there can be lots of headaches, we know that we're helping a lot of people, right? And we're helping to solve the housing crisis as well. So it's great to have you with us today. And I just want to mention that, man, we probably have like 20 new forms on the website, new or revised on the website, with more coming. So always use the newest forms by logging into your AOA account. If you're not an AOA member, we do have a 100% money back guarantee, no questions asked in your first year. So if you do sign up, you will have that money back guarantee, and we want to invite you to join for sure. And yeah, so we have the forms, and we have an update for the tenant screening coming. The previous address history is coming soon here, and we expected it to be put in yesterday, and we've had some real challenges with staffing, and anyway, those things are being resolved and taken care of, and so we're excited about getting that in there. And that, it's so important to have a good previous address history so you can do your due diligence and see what those applicants were like as residents or renters in other locations, right? And yeah, so last week we had a legislative update for the Bay Area. Not this week, but next week we'll have a legislative update for San Diego. And so this one's more specific to LA County. And yeah, so besides that, we have the AOA Trade Show coming up April 19th. And if you've never been, it's a must-see event for sure. It's not going to be one that you can see virtually. It's one that you have to go in person for. It's a free admission. We ask that you bring some canned food, and that will go to feeding the homeless. And so yeah, bring a can of food. But the reason you want to come is we have just a loaded slate, incredible speakers, all experts in their fields, and including our speaker today will be one of those speakers. And we have over 150 booths for sure, lots of vendors. Last show we had at the Long Beach Convention Center, there were over 20 booths, different companies that gave away $100 at least in in raffles and things like that. And this time around, I anticipate that being about the same. We'll also give away an Apple Watch, also give away free cruises. And but better than that, if you're not a member, if you do go to the show, you will get a free 6-month membership if you've never been a member before. So I want to encourage all of you to show up. And I guarantee you're going to walk away with information that will help you manage your properties better and hopefully take you to the next level. And so yeah, so you can subscribe to this YouTube channel, but you also can subscribe to our newsletter. And if you go to aoausa.com, and down at the bottom there's a place where you put in your name, and we just need the zip code so that we send you relevant information. And anyway, so here we go. Finally, we get started. Our speaker today has been in business for, gosh, I'll have to ask him here how many years it's been, but it's decades. And he's an owner himself, and he specializes in landlord-tenant litigation, also including evictions. And he writes articles for us, and all over the place he writes articles and does seminars with us like this. He will be at the $1 Million Trade Show. And let's see, he's on multiple legislative committees where he reviews and interprets proposed legislation affecting the rental housing industry. And this is a guy that I love his presentations because he's so thorough and comprehensive. I love it. So it's my pleasure to introduce to you today Michael Brennan. And so, yes, take it away, please.
Thank you, Jeff. Okay, as many of you already know, my name is Mike Brennan. I run a landlord-tenant eviction firm. Really, landlord-tenant's a misnomer. We represent landlords exclusively. But I have been asked to talk today about the county's and so you can make some decisions based on what you think is going to happen in the next couple of weeks. But for right now, the moratorium is set to expire March 31st. And so what I want to talk to you today about is I'm going to break down evictions and the moratorium into the 4 big eviction categories. And we're going to go through each category and talk about who's protected, who's not protected, and what a landlord can and cannot do. And I think by the end of this presentation, many landlords are going to be very surprised at how limited the protections are compared to what they used to be, even 6-7 months ago. One thing I would like to address real quick is there has been a significant change in the county's moratorium in the last few months. Many of you have heard this already. Many of you know this. Many of you may not know it. But several months ago, there was a lawsuit filed by AOA and AGLA in partnership. And in federal court, the federal court issued a ruling, and the volume just went out. Okay, so maybe
we can hear you. Yeah.
Okay,
we can hear you.
The federal court issued a ruling. They actually issued an injunction against the county. So that was a huge loss for the county, a huge gain, a win for the landlords. What the injunction basically said was that the moratorium was unconstitutional the way it was written because it was vague and confusing, and it wasn't clear enough to allow landlords to know what they could or couldn't do. And the big distinction, as a result of that, the county went back and rewrote several portions of the moratorium. And the most current version is a huge difference from the prior versions. Specifically, the prior versions stated that a tenant shall not be evicted in many of the provisions. And so it sounded like landlords were prohibited from filing evictions. Moreover, the moratorium stated that there were these horrendous fines for landlords who violated the moratorium. It made it very scary for many landlords. When the county rewrote that moratorium, they changed that language completely. It now no longer says that a tenant shall not be evicted. In fact, the way they word it now is such a significant change that it shifted the burden to the tenants. And what I mean by that is the way the moratorium is now written, it states that it doesn't say that a tenant shall not be evicted. Now it states that the tenant can raise the moratorium as an affirmative defense in an eviction. And that's a huge change. So in other words, landlords in most cases are allowed to file evictions. There's some exceptions, we're going to go through them, but in most cases, landlords are allowed to serve notices of termination, file evictions. Then the tenant has the ability to raise the moratorium as an affirmative defense And then the burden is on the tenant to prove that they actually meet the criteria that would allow them to use the protections of the moratorium. So, as I said, that's a huge win for the landlords, and that's the current moratorium as it stands. Basically, one other thing that the moratorium states is that it specifically states that a landlord is not violating the moratorium by filing an eviction if the landlord believes that the tenant is committing fraud, in other words, lying about being impacted by COVID, or if the landlord believes that the tenant cannot prove that they've been impacted by COVID. So for every tenant out there that's claiming they've been impacted by COVID, a landlord's actually not violating the moratorium by serving a notice, by filing the eviction, and then by making the tenant come to court and prove that they were actually impacted by COVID. Again, the two criteria that a landlord can rely on to avoid any sort of allegation that they violated the moratorium is landlord can file the eviction if they believe the tenant's committing fraud, lying, or if the landlord believes that the tenant cannot carry their burden or cannot prove their case that they were really impacted by COVID. In other words, if landlords believe that the tenant's scamming the system, they're specifically permitted to file that eviction. And then the tenant has to prove that they actually meet the criteria for those protections. So to put it simply, landlords in most situations are permitted to file evictions. Now, like I said, we're going to walk through the big four types of evictions that landlords typically file, and we'll go through the specifics of who's protected and who's not. So the big four are non-payment of rent, breach of the rental agreement, something other than non-payment of rent. We have no-fault evictions, and then we have nuisance evictions. Those are the big four categories of evictions. So we'll take those one at a time. Let's start with landlords. Let's start with can a landlord evict a tenant for non-payment of rent right now? And believe it or not, in most cases, the majority of cases, the answer to that is yes. Landlords can serve notices and file evictions for non-payment of rent right now in most cases. A large majority of the tenants in Los Angeles County are entirely unprotected by the moratorium today when they fail to pay their rent. And in fact, it's only a very specific category. It's low-income tenants who are still protected by the COVID moratorium. And that's only if they meet certain criteria that we'll go through in 1 second. So a small percentage of tenants are considered low income. Basically, it's any tenant that falls at or below 80% of the adjusted mean income for the area. And I can hear many people saying, well, how do I prove that? How do I know if my tenant falls at 80% or below adjusted mean income? The good news for landlords is you don't have to. That is not your obligation to carry in court. It's the obligation of the tenant to prove that they are at or below 80%. Now, if they can establish that they're at or below 80% AMI, and they can establish that they met some other criteria, such as giving notice to the landlord within 7 days of not paying rent, and that they were substantially impacted by COVID, and I'm going to explain what that means in a second, then yes, they will be protected. But if you think about mean income roughly, this is not an exact definition, but mean income is almost the same as the average income. So if you take the average income, roughly 50% of people fall above it and roughly 50% of people fall below it. This doesn't even protect that group of people who are in the average income. It protects only those people who are at or below 80% of the average income. So again, like I said, that's a small percentage of people, and the tenants still have a burden to carry, even if they fall into that group. So let's walk through that. What does that mean? So basically what a tenant's got to prove is they are, one, at or below 80% of the adjusted mean income. And they can prove that through receipts, check stubs, letters from employers, whatever they can use to prove it, they're allowed to use that. Fine, no problem. But they also have to prove, and this is important, that the inability to pay rent is the result of them being financially impacted or the result of financial impacts due to COVID. So what does that mean? Well, in the moratorium, what it means is that the tenant has to produce evidence that their failure to pay rent is because of a substantial loss of income caused by the COVID-19 pandemic. So how do you define substantial loss of income? Well, luckily the county provided that information for us to prove that something is a substantial loss. it's got to be a loss. The tenant has to have experienced, or the household has to have experienced, a 10% loss over the income they had for the 12 months immediately preceding COVID. So in other words, March of 2019 to March of 2020, they have to have lost 10% of their income over that time period. But more importantly, they've got to prove that it was a result of COVID. That's the exact language of the moratorium. So it isn't simply that, hey, I'm making 10% less than I used to make prior to COVID. Okay, you're making 10% less, but you still need to prove that it's because of COVID. And most tenants, even low income tenants right now, would be hard pressed to prove that the reason they're making less money right now is a direct result of COVID. Now, there's one other definition they could use to prove substantial loss, but again, they've got to prove it's related to COVID. It's a 7.5% increase in or extraordinary cost. In other words, unusual costs, expenses, we would call them, to their household. Again, it's one thing to say I've got more than 7.5% increased costs. It's another thing to say, and they're directly related to COVID. So let's say, for example, fuel costs. Yes, fuel costs have gone up for everybody. But unless you're shuttling around somebody who's sick with COVID to the hospital or doctor's appointments, then how are you going to prove that an increase in costs is directly related to COVID? So that they've set the bar, in my opinion, it's not that easy for a tenant to prove this stuff. And the tenant does have to prove it. Again, because of that federal court injunction and the county's rewording of the moratorium, they've changed this to basically shift the burden of proving this stuff to the tenant. So the key to remember is that the tenant has certain criteria. First of all, the moratorium doesn't protect everybody. It's only the low income tenants who are at or below 80% adjusted mean income. The tenant has to notify the landlord within 7 days of rent becoming due that they are unable to pay it because that they are at or below 80% AMI. They're unable to pay their rent because of COVID. And if they can do that, if they can establish that, then they've got a right, they've got the rights to the protections under the moratorium. But that key is to remember that most people can't fall into that. So again, I want to reiterate this. I talk to people every single week who still ask me, well, I thought we couldn't file evictions. And then when I start talking to them about their case, I find out the odds are that very good that their tenant is above 80% AMI. They're not impacted by COVID, and they are actually allowed to be filing evictions. And the problem that they're running into at this point is because of that confusion, the balance has grown to a tremendously large amount. Balances used to be, $2,500, $3,500 before a landlord would file an eviction. Now we're talking tens of thousands of dollars. And believe it or not, when you file an eviction, for anything over a certain amount in court, you go into what we call the unlimited court system. And I was just explaining this to Jeff before we started the webinar. The unlimited court judges in LA County are starting to get a lot of these cases that they don't like. They don't want them. They don't like them. Their courtroom is not really geared for unlawful detainer. And so they're bottlenecking in court. And those judges are starting to mandate that the parties comply with rules that the unlawful detainer courts normally wouldn't comply with. So it's slowing the cases down, it's bottlenecking everything, and it's creating more problems for the landlords, all because the landlord didn't understand that they can, in fact, file these unlawful detainers for non-payment of rent. So recap, most tenants in Los Angeles County are no longer protected for non-payment of rent. And I encourage any landlord out there who's got a tenant who hasn't paid rent for whatever period of time to reach out to any landlord-tenant attorney that does it for a living. Not an attorney that will just do it to do it, but an attorney that specializes specifically in that topic. Reach out to them, go over the facts of your case with them, and see if you can file that eviction right now. One reason I say that, again, we'll talk more about this later, but the reason I say that is because it is likely that this moratorium will get extended, in my opinion. And if you don't do this now, that extension could cause greater problems for you down the line. So I want to, real quick, before we move on to the next category, I do want to also bring up that there are some new notice requirements for non-payment of rent in Los Angeles County. Beginning April 1st of 2023, landlords who want to evict those low-income households for rent that accrued between July 1st of 2022 and March 31st of 2023. So basically last July to 2 weeks from now. If you want to evict a household that's at or below that 80% AMI, you have to use a 30-day pay rent or quit notice rather than a 3-day as of April 1st. And just to add to that, if the property's in the city of Los Angeles, you're also now required to list the number of bedrooms on that notice. So there have been changes to several of the notice requirements, I should say. Again, if you're a landlord that's trying to do this on your own, it's very likely that you will misstep. I don't encourage you to do that. I encourage you to reach out to some firm. Doesn't have to be my firm. Hopefully it is, but if it's not, that's okay. Some firm that really knows what they're doing. All right. So one other thing about that new notice, that 30-day notice, that does not void the county's, just because they gave you that way to approach it, does not mean that the tenant's repayment period is done with. In other words, for that narrow group of people who really are protected, low-income tenants at or below 80% AMI, really genuinely still impacted by COVID, who can demonstrate it, their repayment window is now, they're going to have up to March 31st of 2024 to repay that rent that accrued in that little window I just talked about. So any rent that accrued between July 1st, 2022 and March 31st, 2023, if you have a tenant that is legitimately low income, legitimately impacted by COVID, they have up until March 31st of 2024 to repay that. All right. So with that said, I will add one last sentence about that notice. That notice never expires. In other words, you will have to serve that notice even 9 months from now, 10 months from now. Even if the moratorium does expire, you still have to serve that notice if you're asking for that rent in that narrow window. All right. So if you're seeking it through an eviction, I should say. All right. The second category of the big four categories is a breach of the rental agreement for something other than non-payment of rent. And I can already hear people saying, no, that's not it. There are certain categories you can't. That is absolutely true. We're going to talk about them. But generally speaking, in any breach of the lease agreement that is not a non-payment of rent breach can be remedied through an unlawful detainer. In other words, you can serve a notice and file an eviction action. So let's take, for example, the tenants causing damage to the property, tenants allowing certain conditions to exist on the property, a tenant who's parking in a no parking zone where the lease specifically states this is your parking space, tenants who refuse to or who are altering or modifying the property. If your lease has a provision that says don't do this or you're supposed to do this, and they're breaching that lease, then you are permitted to file that eviction right now. Now, the two exceptions to that, there are two categories that remain protected, and even those categories have exceptions. And of course, those protected categories are for unauthorized occupants and unauthorized pets, right? If your tenant has unauthorized occupants or pets, there are still some limited protections in place for those tenants. So again, we're talking right now, the way the moratorium is set up, through March 31st, tenants who brought in unauthorized occupants or unauthorized pets between March of 2020 and I think it's January 20th of 2023, so about 6 weeks ago, those people are protected from eviction. Unauthorized occupants, unauthorized pets are still protected in all 88 cities throughout the county. But here's the caveat. The tenant has to prove two things. The tenant has to prove that the unauthorized occupant or pet took possession within that window, which is pretty easy. But the second one, they have to prove that the unauthorized occupant or unauthorized pet is necessitated by COVID. So what does that mean? Well, it means that the only reason they're there is because of COVID. So if you have a tenant, for example, whose brother, let's say that brother lost his job 2 years ago as a direct result of COVID, but is still there. Are they still there because of COVID? Well, I don't know. That's something that we could flesh out in an eviction case. Maybe through discovery, we might ask, okay, how many job interviews have you gone on? How many offers have you received? Have you had any employment? So there are some limitations to that. Now, of course, anybody who's moved in after after January 20th of 2023, 6 weeks ago or so, they're not protected at all. So every week I'm talking to people who call me up and say, oh, we just noticed that somebody just moved into our tenant's unit and they won't talk to us. They won't tell us anything about it. Guess what? They're not protected. Or an unauthorized animal, which is a completely different story. There's a whole rabbit hole we could go down with animals that is outside the scope of today's topic, but so we won't address it. But the point is that any unauthorized occupant or pet that's come in after January 20th of 2023 or is not necessitated by COVID allows the landlord to file an eviction against that tenant right now. So there is no protection for there. Very narrow protection, I should say. Real quick, I just want to make sure I'm not missing anything before we move on to the next big topic. Doesn't look like it. Let's talk about the new notice requirements for that. In situations where the landlord believes that the tenant can prove that the unauthorized occupant or pet was there due to COVID, the landlord will still be able to file that unlawful detainer action after March 31st. So in other words, as of April 1st, there's no more protections for those unauthorized occupants or pets, no matter when they moved in, even if they're necessitated by COVID, and you will be able to terminate that tenancy if the tenant doesn't remove them. Now, the caveat is that it's like the other notice I mentioned, it's a 30-day cure or quit. So again, if you're getting your forms from the trade organization, great, fantastic. They do a fantastic job at doing the forms correctly. If you're trying to do this on your own, I don't suggest it, but if you're still going to do it, make sure you're using a 30-day notice rather than a 3-day cure, covenant, or quit. All right. Other than that one category, again, just to reiterate, all breaches of the lease are unprotected, even as of today. So that brings us to the third category, which is no-fault evictions. Now here, admittedly, this is where the moratorium has the most protections out there. There are essentially, for all 88 cities in the county, there are essentially no-fault evictions at all permitted right now. The only exception to that is if the owner of the property or an immediate family member wants to occupy the property. And of course, there's a tremendous amount of regulatory requirements they must meet, limitations to this. But if an owner wants to occupy the property, in most cases, they are permitted to do that. However, there are a significant number of limitations. The most important limitation, I don't want to waste any of our time going through a bunch of administrative things they need to comply with, such as serving a declaration of intent to evict to the county, all these hoops they have to jump through. They have to pay relocation fees. If there's none in the city that the property is located in, then they have to pay the county's relocation fees. But the big issue that landlords need to understand is there's a provision of the moratorium that says even if you're doing an owner-occupied eviction, the owner has to be similarly situated to the tenant. So what exactly does that mean? Well, it means that if the tenant is low income, the owner has to be at low income. And I want everybody to focus on that one because I think that's the hardest one for a landlord to comply with, right? If the tenant is terminally ill, maybe this one's the hardest. If the tenant is terminally ill, then the landlord has to be terminally ill. If the tenant is disabled, the landlord has to be disabled. If the tenant is low income, the landlord has to be low income. And I really don't know too many landlords who really legitimately will fall into a low income category. Now, what you could do is if you were, for example, I'll just make an example up. Let's say your son or daughter was about to go to college and you wanted that unit for them to occupy it while they're in college. Great. My guess is if they're going to college, they would fit into the category of low income. And then that would be perfectly acceptable if your tenant is low income, as long as you follow all the administrative procedures. It would be perfectly acceptable to terminate that tenancy for an owner-occupied tenancy. But again, it's a very narrow window of landlords who are going to fit into that. So essentially, until March 31st, there are no-fault evictions in any city within LA County, unless you fit that narrow category that we talked about. So before I move on, the last category I want to discuss is nuisance, but I do want to add one before that. It's a very narrow category. The county's moratorium does also allow evictions for denials of entry. And I believe it or not, that has been significantly larger. That basis for an eviction has been significantly larger during COVID than it had at any time prior to COVID. And essentially what the moratorium says is if a landlord needs, or a landlord's agent, if the landlord needs to get into that property to make habitability repairs or something along those lines, and the tenant is denying access to the property, then the landlord can, in fact, file an unlawful detainer. Another category, well, we're going to talk about nuisance right now. So let me go into nuisance before I discuss that one last category of denial of entry. So nuisance is the other category that's really interesting. The moratorium specifically states that the tenants may raise the moratorium as an affirmative defense to an eviction based on a nuisance. Now, nuisance has 3 or 4 different definitions in the California laws. And so what constitutes a nuisance is a very, very broad category. You can have anything from playing music loud all night long on a consistent basis so that it's destroying the quiet enjoyment of the neighboring tenants, to just being verbally abusive to people on the property, to beating people up, to stealing from other neighboring tenants on the property. Nuisance is a huge category. So while the moratorium does allow a tenant in any nuisance action to raise the moratorium as a defense, there's a completely separate provision in the moratorium that is what I'll call a backdoor to most nuisance cases. So I mentioned, for example, the nuisance where you've got somebody who's moved into the unit and, every Friday and Saturday night, they're blasting their music all over the place. You've got good tenants calling you up saying, hey, I'm going to move if you don't stop this. I think that that's the kind of nuisance that you're going to have a hard time prevailing on in an unlawful detainer court. However, there's another provision of the moratorium that states, I'm going to paraphrase it, but essentially any type of nuisance or any type of health and safety concern that's being maintained on the property by a tenant would allow a landlord to evict the tenant for that basis. Also, the way they word it is, you could evict somebody for behavior that if it's necessary to maintain the health and safety of the building, or if the tenant's behavior is a threat to the public health or safety. So for example, like I said, if you've got tenants who are, I don't know why we've had such a rash of this recently, but we've had quite a few cases where tenants are lighting huge fires on the property, and they're going to burn the building down, and they're going to burn the neighborhood down if they're allowed to remain in possession. So that's the type of situation where that's a nuisance behavior. And so you are allowed to terminate the tenancy for that. Like I said, the only nuisance that I can see that would be difficult to really prevail on would be that guy who's just obnoxiously playing his music, or that woman who's obnoxiously playing her music, somebody who's, yelling at obscenities at people as they walk across the property. Yeah, those are the types of nuisances that are, I think, specifically protected by the moratorium right now. So having said all of that, like I said, we'd come back to denial of entry. So getting back to the denial of entry, what type of situation would allow a landlord to file an unlawful detainer action based on a denial of entry? Well, like I said, if there are habitability issues on the property and the tenant is not allowing access, that would be a basis for a termination. More so, if you had a situation where, for example, I have several clients who have found either there's asbestos in the building that's exposed to tenants, and the tenants refuse to allow the landlord in to make the repairs, to abate the materials. We've had several instances where it was the tenant who brought the landlord in and showed the landlord, I have mold in my property. And then the tenant says, oh, you can't come in to make those repairs. Those are the types of situations that are specifically not protected. The tenant is not protected in those situations. They have to allow the landlord in. And if they refuse to allow the landlord in, then the landlord can file an unlawful detainer for refusal to allow access, or denial of entry, as we would call it. So those are the 5 big categories of unlawful detainers that are the most common categories of eviction. And like I said, if you go through those, each one of those, yes, there might be a narrow class of people that are protected, but they all have certain criteria that they must meet in order to avail themselves to the protections of the moratorium. Most situations, they can't do that. Like I said, non-payment of rent, you've got a tenant who's got to prove they're at or below 80% AMI, they've been substantially impacted, their expenses have gone up, their income has gone down, it's got to be directly related to COVID. There are all these hurdles they have to make it over. breach of contract. The only category protected is unauthorized occupants and pets. They're only protected, even if it's completely legit and it really was impacted. I mean, due to COVID, they're only protected for 2 more weeks. But most cases, they're not due to COVID. And it's pretty easy to prove that. Nuisance cases, we've talked about, denial of entry. Basically, what I'm driving at here is the majority of landlords who have problematic tenants can file an eviction right now and should not hesitate to do so, because, as Jeff and I were talking about before we actually went live, that large group of landlords out there who have a misunderstanding and have thought for the last 3 years, hey, I'm not allowed to file an unlawful detainer. When this moratorium finally does expire, though, that group of people is going to run to court to file these evictions, and that's going to bottleneck the whole court system again. So there's 2 other topics I want to talk about today real quick. Repayment periods, what's coming, what the tenants are obligated to do as far as repayments are concerned. And then I want to talk about where I think we're going in the next, let's call it 3 to 6 months, as far as the moratoriums are concerned. So repayment periods, let's talk about what a landlord can and cannot do right now. For unpaid rent that accrued between March of 2020 and September 30th of 2020, that's called the protected period. A landlord cannot file an eviction for that because it's more than 1 year ago. The rent accrued more than a year ago. So you can't do a notice for that. Many people on the phone right now are saying, well, what about generally accepted accounting principles, et cetera? The state laws really knocked your ability out to use that, because they said that whatever rent was paid had to be applied to the month in which it was paid. The prospective month is the way they worded it. So essentially, you can't do evictions for that protected period. But what you can do right now, the tenants were supposed to pay the landlords back by September 30th of 2021 for that period of time. So if a landlord did not receive housing as key, did not receive any money from the tenant for rent that accrued between March of 2020 and September 30th of 2020, the landlord should go right now and file an action in small claims court for that money. The next period we talk about is the transition period. And this is the period of time that was largely controlled by the state laws, AB 3088. I forget the other ones now, but all the state laws controlled that. And that period of time was October 1st, 2020 to June 30th of 2022. And the repayment period for any rent that accrued during that period is August 1st, 2023. So that's coming up in what, 4 months from now, 5 months from now? So if the tenants have not repaid you by that period of time, in most cases, again, you can't go back more than a year in a non-payment or a pay rent or quit notice. So you're going to end up having to file a small claims action for the tenant, against the tenants for the rent that accrued in that period of time. And then the last period of time under the county's moratorium is what they're calling the extension period. And that ran from July 1st of 2022 to March 31st of 2023. In other words, the expiration of the moratorium. And the payback period for that is 12 months, or March 31st, 2024. So again, a lot of people have told me, well, then if they've got that payback period, then we can't file an eviction for it. That's not accurate. Again, the tenant has to meet that criteria of being low income, substantially impacted by COVID. They have to prove it. So outside of that, if you legitimately think your tenant is low income, they were really impacted by COVID, yeah, I wouldn't encourage you to serve a notice on that individual right now. They've got a repayment period of March 31st, 2024. See what you can do to work with them. See if you can get them on a repayment plan. But if you have any doubts at all, like I said, the moratorium states, if the landlord believes that the tenant is committing fraud, or if the landlord believes that the tenant will not be able to prove that they are legitimately entitled to the protections in court because they were impacted by COVID, file your eviction right away. Don't worry about that repayment period and don't wait. But again, it's a very narrow category of tenants who are protected by that non-payment of rent issue. So let's talk about rent increases and pass-throughs real quick, and then we'll talk about where I think we're going. In unincorporated Los Angeles, rents are, you'll be able, as we sit right now, you'll be able to increase rents as of April 1st, 2023, as we sit today. I'm not sure that will happen. Pass-throughs also will go into effect April 1st, 2023. But what I believe will happen, well, before I get there, all other cities, all other 87 cities or 88 cities, I guess, in the county, you're going to have to look at your local moratorium and what it said. So, for example, the city of Los Angeles has several different payback requirements and periods for RSO versus non-RSO. Right now, we're just talking about the county. But in general, look at the city that your property is located in first to see if they have an existing moratorium and what it says about rent increases. Several cities have limitations on that. And then if you're in the county as it stands today, April 1st. But now we're finally at the point where I'm talking about what I think is going to happen. So moratorium set to expire March 31st, 2023, basically 2 weeks from now. If history is any indicator, and I think it is, I would say don't count on that. And there's several reasons. The last iteration of the county's moratorium before they had to make the major changes was January of 2022. And if you look at the last page of that moratorium, the county was very clear about what their intention was. They intended to continue this moratorium through June 30th, 2023. Now, a couple things got in the way. They ultimately voted to let it expire March 31st, 2023. But there have been every single county meeting, there have been several county supervisors who are putting forward motions to extend this through, and some of them beyond June 30th. And they, like I said, on that January 2022 moratorium extension, they specifically stated, what we want to do is we want to keep this thing in place because we learned a bunch of lessons in connection with tenant protections. And we want to use that additional time to implement these tenant protections. And so that's why we're doing this. I mean, they blatantly said that on the last page of that extension. Now, here we are closing in on March 30th. At the last Board of Supervisors meetings, it was supposed to expire. Last minute Hail Mary by a couple of the supervisors. Oh, no, we're not expiring it. We're just going to extend it another 90 days. Okay. So if their original back in January 2022, if that moratorium stated that they want to extend it through June 30th of 2023, why wouldn't they do that now? Every single time they've had the opportunity to let this thing expire or repeal it, they have disappointed landlords by extending it. More importantly than just my suspicion that they're going to extend it through that third tier period, that original third tier period, is a motion put forth by Hilda Solis and Lindsay Horvath. And this motion was put forth on January 24th, 2023, so just roughly 6 weeks ago. And what that motion said was, it's interesting. The motion has several different dates in here. The main one I could point to make everybody feel a little bit better is they want the moratorium extended through June 30th of 2023. Now, at this stage, if it were to be extended the way it exists today, I would not be happy about it, but there's worse things that could happen, especially since I just pointed out most evictions could move forward today. Most, not all, but most. The problem is there's other dates in this motion. For example, it appears that they are attempting to have the resolution itself, at least, go through January of 2025. So if you read that motion, maybe it's a typo. I don't think so. I believe that they really want this to go through 2025. And I believe that the purpose of it is, as they stated back in January of 2022, because they are still trying to get a lot of tenant protections structures in place, not just in LA County, but in various cities throughout the county. It's no secret that the county is working hand in hand with several cities throughout the county to help them structure their tenant protections ordinances. And if you've been following what comes out through the trade organizations, everybody's aware multiple cities right now are considering new tenant protections and rent controls. That's no surprise. It's no secret. So do I anticipate that it will be extended through June? I will not at all be surprised if it gets extended through June. Do I see that at least a couple of the supervisors intend to push it through farther than June? Yeah, I clearly see that. If you read that motion, from Solis and Horvath, they all but come right out and say that's our intention, is to continue this through 2025. I do think that they have some challenges doing that. they are specifically stating that they want to extend the COVID moratorium. The problem with that is even the county itself is about to expire the county's state of declaration of emergency in connection with COVID. That expires March 31st. So if there is no more COVID emergency in the county, the county itself will have a hard time explaining why the COVID moratorium has continued. But the problem is they have other avenues that they can take. So, for example, many of you know, as soon as Mayor Bass got into office, one of the first things she did within a couple of days was issue a state of emergency regarding homelessness. And so now that is the path that some of the supervisors are talking about. They've specifically tasked the executive director of the county to turn in a report within, I think it was either 30 or 45 days from that January 24th date. And that report is how can we use the homelessness emergency to extend these protections. So now they're shifting gears on us and saying, okay, we can't use COVID anymore, so we'll just attach it to the homelessness issue. So the best case scenario is it just doesn't happen. I wouldn't count on that. The next best case scenario is that, okay, so they attach it to the homelessness, but the tenant protections are, relatively minor, or they're designed to help the very low income out there. The worst case scenario is that they attach it to the homelessness emergency and they just go all out and do a full-blown Tenant Protection Act that we will have to litigate in court, which we will do if it comes down to that. There's multiple lawsuits against different municipalities and the county right now. We will litigate it. The problem is whether we'll be able to get an injunction against it while it's being litigated. And litigating these type of issues, as everybody has experienced now, litigating anything COVID related or these type of landlord tenant issues, they don't go through the eviction courts. So they go through a regular civil calendar, and that takes forever. As the saying goes, the wheels of justice grind slowly. And so it will be years, potentially years, if we can't get a preliminary injunction, it will be potentially years before we get substantive rulings that these moratoriums or these tenant protections that are assigned to the homelessness crisis are invalid. I do believe that we have the best Supreme Court, the United States Supreme Court. We have the best Supreme Court sitting in decades to hear these kind of issues, but getting these cases to the Supreme Court is no easy task. And like I said, it takes a long time. So the short-term prognosis is, like I said, you can do a lot more evictions than you think you can right now. So talk to an attorney. The mid-range prognosis is that, look, I won't be terribly disappointed if they extend this moratorium because I expect them to extend it. A longer-term prognosis is, man, if you thought what was going on in landlord tenant laws was bad before COVID, and even during COVID, you should gear up for a fight now. I don't see any of this going away. We have a very progressive board of supervisors. We have a very progressive city council in the city of Los Angeles. Many of the cities throughout the county, their city councilors are becoming more and more progressive. And so this is going to be a big battle. So hopefully that was a short enough and succinct enough overview of the county's moratorium to shed some light on some otherwise confusing topics. And Jeff, if you have any questions at this point, I'd be happy to take them.
Great. Thank you so much, Mike. That's just so thorough, going through exactly why there aren't that many tenants that really do have protections right now. Really unjust, unreasonable protections, so we're really very glad that we did the lawsuit and that we forced that change. And I did speak with our attorney this morning, and he's getting our paperwork ready. So we are planning to file a motion for summary judgment, and that's coming up here if they extend or at the end of the moratorium. So we got some timing on that. I thought we were going to do it a little earlier, but they're looking at doing it in the right timing for it to make sense.
Well, to be clear, for your members who don't know exactly what you're talking about, you guys are considering filing a motion for summary judgment in the case in which you actually won that hearing, that preliminary injunction. Yes. And the county did go out and change that moratorium. I still agree that, yes, we should go file that motion for summary judgment, especially if they extend the moratorium. So, I'm glad it's moving forward. it is a struggle. It's not, this type of litigation is not easy. Just that victory alone was, a tremendous, I won't call it a windfall because it was hard fought, but it was a tremendous victory for landlords. And I don't think most landlords understand that. At least it put the county back on their heels and said, hey, maybe maybe we can't steamroll these guys the way we thought we could. Maybe we might actually have to do this in a legal manner.
Right. And hey, Mike, I want to say thank you to you because you were part of our legal counsel that said, hey, guys, this is one you should go after with your political action committee. So thank you. Really appreciate you and being on the same team, fighting, the same battles. And so, yeah, really appreciate it. And then you members that have given to the Political Action Fund, thank you, because without it, how are we going to pay an attorney? So thank you for giving. And there's always that opportunity to give. For even what we're doing right now, what they're preparing. They're almost done preparing it, but we haven't paid the bill on it yet. So go to the AOA
bill always comes later.
Yeah, AOAUSA.com, and there'll be a little pack advertisement. If you click on it, then scroll all the way down. There's a place to give. And anyway, everybody chip in, please, because the bill's going to be coming.
Yeah, I guess I'd like to close today by reiterating that. I think I've said in the last 18 months, prior to 18 months ago, I've never asked anybody to contribute a penny to anything. But man, all the contributions help. This is not cheap stuff. It's not easy stuff. To foot the legal bills that have come out of this is a tremendous effort. So anything that people, can look into. I mean, the benefits all flow out to the landlords, to your members, so any contribution from the landlords that they can make to assist us in funding this, you can win, you can get victories. Look, we just did, right? We got a victory and pushed the county backwards, and we may just end up with another victory on that MSJ, but it costs money.
And we report on that to the government, so there's full transparency on it as well.
Right.
Just in case you're wondering. All right, here we go with Marta on YouTube. I have an applicant who will be moving in on May 1st. If they sign the lease now, will they be responsible for lost rent between now and May 1st if they ultimately don't move in? Can I charge them for advertising expenses?
Ultimately, if they don't move in. So that's a great question. So yeah, if somebody signed a lease right now, and I forget what the name of this document is called, but I could get it to them if they call my office. I'll get them a copy of this document. But I used to do basically a contract with people that said, hey, if you sign this contract and you don't take possession, then you're going to be responsible for, I would take a deposit, and you're going to be responsible for the rent that accrues between now and the time you tell me you're not taking possession. So yes, they would be ultimately responsible for that, but I would encourage you to make them sign something that they acknowledge that says, hey, yeah, I get it. You took that property off the market, and so I'm responsible for that rent that accrues in that time period.
Oh, and hey guys, just as you're asking questions, we really need the city, which city you're in, because it makes a big difference. And, when we have partial information, we give answers that are more general. And, we are pretty much giving general answers anyway, but it may help you or help the other people listening if you're more specific. All right, Shirley on Facebook. I have a long-term tenant, 5 years, who recently renewed her lease. Since it's only been a couple of months since she renewed. Okay. Under AB 1482, can I do an eviction without giving a reason or compensation because the current lease is less than a year?
I think what she's trying to say is, I'm speculating here, but I think what the question is, first of all, if she extended her lease, she's under a fixed term lease. And you can't terminate a tenancy for any reason under a fixed term lease. It's got to be non-payment of rent, breach of contract, nuisance, all the things we just talked about, right? So it sounds like what she's saying is, can I terminate it without doing a no-fault eviction? And if that property is located anywhere in LA County, the short answer is no, you can't do that right now. If they allow the moratorium to expire, then circle back with me after April 1st, and we can talk about the specifics of your case. But it sounds like there's two things preventing her from doing a no-fault right now. One, she renewed the lease. So she's in a fixed term. 2, you've got the county's moratorium saying no faults. So it doesn't sound like she can move forward.
Okay, there we go. Thank you. And Ken here, if a tenant owes you 10 grand in back rent, can you offset this amount toward relocation cost in a no-fault eviction?
The short answer to that is, again, it's going to depend on what city you're in. But in general, the short answer to that is yes, specifically if it's in the city of Los Angeles. Their new tenant protections specifically state that if you're going to be doing I forget what the economic displacement, for example, if you give the tenant an increase of greater than 10%, the tenant decides to, terminate their tenancy because of that, and they're entitled to relocation fees. Yes, you'd be able to offset that unpaid rent. Most of the time, any unpaid rent can be offset against the relocation fees.
All right. Here's a ESA question from Peter on Facebook. Do all tenants in a unit need to sign an ESA animal agreement, or only the tenant with the ESA?
I would state that a little bit differently. I would say it's the tenants it's the named lessees that should sign that animal addendum. It doesn't matter. So you can have, let's say you lease to me, right? And I move my brother in, and you're okay with my brother, but you never add him to the lease. And then my brother gets the ESA, right? Really, the guy you want to sign that animal addendum would be me. I'm the guy on the hook for the lease. Now, if you can get them both to sign, fantastic. Get them both to sign. Depending on what jurisdiction you're in, there's a nuanced argument about whether that would be advantageous for you or not. Maybe you don't want them to sign for various reasons. But in general, get the named lessees to sign. They're the people on the hook.
Great. Monica on YouTube. City of LA, RSO. Tenant moved owing $17,000 from April to December 5th of 2022. Can we take him to small claims court now since he vacated the unit?
I would argue yes. They're not your tenant, and they are no longer entitled to any protections or deadlines. I would take them to small claims right now.
Okay, and then they also asked, is there a limit? No limit in small claims court. And on the amount, can your firm help with the paperwork?
So there's a couple things. Let me start with the limits. Initially, I believe that the state laws did say that it was unlimited, but recently I've heard a couple people tell me that there actually is a limit. It's something like $50,000 or something like that in small claims. So I believe that there is some sort of limit. To be clear, she didn't ask this, but I'm going to answer it anyway. Uh-huh. You have 4 years from the date of the breach if it's a written contract to sue them, and you have 2 years if it's an oral agreement. And as far as getting my office to help with the paperwork, we tried it a few times with a few clients, and it just doesn't work out for us because we can't appear for you in court. And yet, we're running all of the paperwork for you, and it becomes, we're not really tooled for it, I guess is what I'm trying to say. If we send our process servers out to serve them, then it's our process servers who are responsible for getting the proofs of service to court, and they want to be paid for that. So it gets difficult for us to really do that effectively for the clients. So, but what I will say is every court in LA County that has a small claims division has a small claims advisor, and you can go in there and get free help. They will literally help you with the forms and what you need to do, and it's all for free. The one thing I will remind her is before she files that small claims action, if she hasn't already done this, she does need to send a demand letter. Send a letter to the tenant demanding the money, and if the tenant doesn't pay it within whatever time frame you establish, then go to small claims court, talk to that advisor, and get them to help you with the paperwork.
Great. Okay, Notion on YouTube. How long does it take for an unlawful detainer process to end after April 1st if there's no defense?
Well, unpacking that, there's no defense. Everybody believes there's no defense. That's a really difficult question to answer. Let me structure it this way. There are a lot of variables that will determine how long a case takes. So if you're talking about an unlawful detainer where the tenant failed to file a response, that's what you mean by no defense, then you can probably be looking at, depending on the court, the real bottleneck comes with the sheriff. So the court you can get through relatively quickly, most of the time. But the sheriff is where we get the bottleneck. And you and I were just talking about this, Jeff. Many of the hubs have been telling us that, hey, we've only got one sheriff doing lockouts, and they're doing them all. So to answer the question, if you can get through the court relatively quickly, maybe 45 days, but getting that sheriff to do the lockout, it could be anywhere from another 30 days on the short end, another 21 days on the long end, another 90 days. Just depends on what sheriff hub you're dealing with.
Great. There you go. And it's just like, where's the justice,
There is no justice here. We talked about this. This is just a significant transfer of wealth from people who worked really hard for this. And it's all by design. It is absolutely all by design. So demonstrably so. So anyway.
Yeah. So
don't get me started.
I know it. We'll try to stay on task here. We have Alicia from Sun Valley. Can I evict a tenant with Section 8? But Section 8 is ignoring the rent increase request.
So I'm assuming what she means is I gave Section 8 a rent increase request. They haven't processed it yet. The tenant's not, maybe the 60 days has expired or the 30 days has expired. Tenant's not paying their portion. I'm not getting my increased rent. I would not file an eviction in that situation right there because look, right off the bat, Section 8 by definition is low income, right? So they are entitled to these protections. So now in another scenario with a Section 8 tenant, if your Section 8's tenant's portion hasn't changed at all through COVID, there's at least an argument to be made that they weren't impacted by COVID, right? Because if they're impacted, if their income goes down in their household, then their Section 8 will automatically restructure what portion the tenant has to pay, and they'll reduce the tenant's portion. So if you don't have if the tenant's portion hasn't been restructured during COVID and it hasn't gone down, like I said, there's at least an argument that they are not impacted by COVID. They haven't been impacted. So now, if you're talking about a tenant that is simply not paying their portion, regardless of the rent increase request or not, then I would say, again, if they have not had their portion restructured and reduced, I would go ahead and serve that notice and let the tenant raise the moratorium as an affirmative defense, just like they're allowed to do. And then they can try to prove that they've been impacted by COVID in court.
And on that one, if they're in LA City, now they have to also consider that whole threshold to evict deal, right?
That's a great point. I'm really focused on LA County right now, but yeah. What you are right. I'm glad you brought that up, Jeff. That's a fantastic point. With the LA City's new minimum rent threshold law, they have to be behind a full month, and it's not the month they pay; it's the month that HUD, the monthly rent that HUD has determined is the fair market rental value for that type of unit. So, for example, if it's a studio apartment, then you have to look at HUD's numbers. And what does the fair market for a studio apartment go for? Now, here's the crazy part. If the tenant only pays 10% of the monthly rent, it will take you 10 months of non-payment of the tenant's portion before you're even allowed to file that eviction in the city of LA. So, I mean, once again, either ill thought out or well-designed plans to really damage the landlords.
Right. Yeah. And I don't even know if Sunland that's considered LA or is that
I believe Sunland is part of the RSO.
Yeah. Okay. It's such you look at the map and it kind of is crazy. So yeah, some things are straightforward and Sunland I'm just don't know on.
All right, Steve. Less straightforward every day.
Yeah. And this is all intentional, which we talked about earlier.
Yeah.
They're not trying to help us make it. Steve on YouTube, does a non-curable 3-day notice require that Saturdays, Sundays, and judicial holidays not be counted?
For the expiration of the notice, my belief is yes, is the answer to that, because a non-curable is going to be a nuisance, and that's under 1161. And I believe everything in 1161 states not including weekends and holidays for the expiration date. So I could be wrong on that. I could double check it, Steve, but I believe it does. I think on every notice, you're not allowed to count weekends and holidays. And it can't expire on a weekend and holiday, but I don't believe you're allowed to count them either.
Okay, there we go. Mark, what is the process for taking possession of a single family home from a long-term tenant? Lakewood, California. That's a tough one because we have no idea on what grounds.
Right. So as we sit today, Lakewood, I'm trying to remember what county is Lakewood. Isn't that Orange County? Is Lakewood Orange County or LA County? Do you know?
I'm not sure.
Well, let me look it up real quick. But as it stands today, maybe it's Los Angeles County, LA.
I kind of think it's LA, but I'm not sure.
California. Yeah, that's LA. All right. So based on the facts you provided in the question, you've got the only reason you could retake that single family house on a no fault would be owner occupancy. And to do that, like I said, there's a lot of criteria you need to meet. You have to pay the relocation fees. You have to be similarly situated. Whoever's going to occupy the house after you get it back has to be similarly situated to the occupants right now. So outside of owner occupancy and meeting all those requirements, the short answer is no, you would not be able to do that until April 1st if the moratorium does not get extended.
Okay, here's PA on YouTube. This one, I'm not sure about you. I own a multifamily property in my name. I have a tenant who is months behind with rent and is damaging the property. Can a judgment be made against my assets if I try to evict?
I think I understand what she's saying. Is she's looking at this as a risk tolerance perspective. So you've got a tenant that's damaging the property right off the bat. That is clearly outlined in the county's moratorium, allows you to file the eviction for that. No problem. Even in the city of LA, you can file the eviction. Where you might be exposed, and this is what she's really driving at, is can they come after me if I'm exposed, if I've done anything wrong? Assuming you comply with the moratoriums and assuming you haven't legitimately done anything wrong, then you're going to be fine. What I would encourage you to do, because you have the property in your name personally, is I don't know what your net worth is. If you're a high net worth individual, you might want to talk to your CPA about putting it in an LLC or something like that. If you're not a high net worth, and we're talking millions and millions of net worth, at a minimum, I would go out and pick up not only a commercial insurance policy, but an umbrella policy to cover at least what your net worth is, if not more. And then I would feel much more comfortable about moving forward. As long as you're not violating tenant harassment codes, I wouldn't really worry about it. You can't allow a tenant to sit there and cause damage to the property. So if you need to talk about tenant harassment codes and what you can and can't do, and you want to talk about what type of damage to the property, call my office. And, admittedly, getting in touch with me is oftentimes very difficult, but you can talk to my staff members or the associates that work here. One way or another, we will be able to look at your factual scenario and get you through the situation. Right.
And also, she's got to get her ducks lined up. If she has an old lease that didn't have the AB 1482 declaration, then that's got to be.
Or the cap on attorney's fees would be another one.
Right.
Yeah. So there's a lot that you need to do, but you need to move relatively quickly because of the damage to your building.
Yep. Yeah, absolutely. Okay, Michael, does the county supersede municipalities such as Santa Monica, or maybe they meant NoHo? They put WeHo, but probably NoHo.
Maybe they mean West Hollywood.
It's West Hollywood. That's what it is. West Hollywood. There it is.
It depends. In certain circumstances, the county can supersede them. I don't know what situation they're talking about. If they're talking about the moratorium, and does the county have the right to override the cities with respect to the city's moratorium? The short answer is yeah, the county can do that. Yeah. The county's got to meet certain criteria to do that, but I don't doubt that they've done that.
There we go. Okay, can we probe unauthorized occupants? We know for sure have been happening for years.
All right. So again, no city associated with this question. So let me come at this from a broad perspective, and then I'll give a caveat. Right now in the county, you are allowed to evict unauthorized occupants and pets who moved in after January 20th, 2023, with no issues at all. You can go ahead and do that. If they moved in between March of 2020 and January 20th, 2023, then they are protected if the tenant can prove that they're there as the code says, they are necessitated by COVID. Those are the exact words. So if the tenant cannot prove that they're there out of necessity due to COVID, you could evict them right now. Now, if you're talking about broader terms, or I should say more narrow terms, for example, in the city of Los Angeles, the city of Los Angeles they have their own rent control and tenant protection ordinance that puts some limitations on that. The tenant has to be there for 30 consecutive days, but if they're there with your knowledge for more than 60 days, then you can't evict them. You've accepted them as a tenant. So without knowing more about the hypothetical I was given, I've given the best answer I can. What I would say is, if you've known about them for years and the property is located in a location that has a strong tenants protection ordinance, the odds of you being able to evict them for that right now are very slim. On the other hand, if the property is in a city that doesn't have a strong tenants protection ordinance, yeah, you could probably do it, as long as they're necessitated by COVID.
Okay, here's Gabriella on YouTube. Just my Section 8 tenant who moved in her daughter and son, not in the HUD contract or mine, are they protected?
I don't know if she means they as the whole household, or they as the named tenant, or they as the unnamed occupants. In general, so we've got a Section 8 tenant who moved 2 people in without any permission. First of all, they're violating the HUD contract. The HUD contract specifically states that every HUD contract I've ever seen says if they move people into the household without permission from HUD, that they're in violation of the HUD contract. Mm-hmm. Second, unless they can prove that they are necessitated by COVID, assuming this is somewhere in LA County, then she has the right to file the notice to terminate the tenancy, a cure covenants notice. So again, remember what I talked about, new notice requirements, were they necessitated by COVID? It's not all black and white. It's not cut and dry by any means, but it doesn't sound like they're protected right now.
Great. Okay, Johnny on YouTube. I have a 2-bedroom, 1-bath, single-family residence in Woodland Hills. Can I raise their rent when their lease expires in August of 2023?
So you've got a single family residence, assuming it meets the criteria to exempt it from AB 1482 or the Tenant Protection Act, we call it. You're in Woodland Hills, which is obviously in LA County. Right now, the way we're set, I don't see why what would prohibit you from doing that.
Right. Only if you're under RSO would the rent fee freeze?
The county's RSO, right.
Yeah.
But I don't believe he is. He's in Woodland Hills, which I want to say is an incorporated city.
Is it not LA?
It is LA, but he's a single family home, so he doesn't fall under the RSO.
Right, yeah.
Right. It is part of Los Angeles. If it was a multifamily, it'd be RSO. Let's put it that way. Yes, Woodland Hill falls under LA.
Right, okay. So hopefully, I think that got it for him. Okay, Kitty on YouTube. Unauthorized pet that tenant claimed to be emotional support. Can LA Housing prevent the landlord from charging any fees? What else to do? What else to prevent more tenants from doing the same?
Okay, so let's start with the additional fees. Not only can the county do it, the state can do it, and the federal government can do it. The minute somebody claims that some animal is an ESA or a service animal, you are strictly prohibited from charging pet rent, charging additional pet deposits. You, simply stated, doing so would be an act of discrimination, and it would expose you to a lot of liability. So the minute a tenant claims support, emotional support, whatever you want to call it, just don't even think about additional rent or additional fees. Leave it alone. What you do want to do, though, and you can do and you should do, is there's a very specific process to walk through. The tenant has to verify they're disabled. So you give them a packet. We call it a fair housing packet. Tell them, have their healthcare provider fill it out and sign it. They give it back to you. And in most cases, you're going to end up with that animal. But the good news is you can have the tenant sign what's called an animal addendum. And that animal addendum puts some boundaries on that animal being in the property. For example, if the animal is destructive, if the animal is becoming a nuisance to the neighboring tenants, it puts boundaries on there that would allow you to terminate the tenancy. First, it would allow you to get rid of that particular animal. And most tenants will say, no, I'm not getting rid of my cat or dog. And then if they say no to that, then it would allow you to terminate that tenancy. There's not a heck of a lot you're going to be able to do about tenants who pop up with animals. I have had clients that have turned their buildings into pet-friendly buildings because there is a distinction between a pet and an emotional support animal. A pet, you can charge pet rent. You can charge an additional deposit. Emotional support animals, you cannot. So their thought process is, and I agree with them, if it's a pet-friendly building, people will come in and be honest, yes, I have a pet. And right from the get-go, you could charge the pet rent and the pet deposit rather than having that tenant lie to them later and say, oh, it's an emotional support act.
Right. Okay, Charles, what changes after March 31st? So I don't know if they wrote that in before you talked or.
That's a very broad question, Charles.
Yeah.
So first of all, as we sit today, the moratorium expires, but the county's moratorium expires. So essentially everything we talked about today evaporates, goes away. There are some lingering protections and provisions. We talked about this, the payment of rent, the repayment period for tenants who are 80% AMI, and they can prove that they were really impacted. That window, I'll call it a safe harbor for tenants who can prove that they have unauthorized occupants and pets, and they moved in with this window, within that window, and they're necessitated by COVID. That notice requirement, 30 days, remains in place. So there's a couple of things that remain in place, a couple of protections, but for the most part, as we sit today, April 1st, the county's moratorium is gone. And as everybody knows, the city's moratorium expired with a few exceptions of lingering protections, I call them. That expired January 31st. So if all goes well, April 1st, we no longer have any moratoriums anywhere in the county that I'm aware of.
Great. And then, so we'll see what happens. Rena here on YouTube. Can I evict for unpaid rent from April 2020 and March 2021? So I wonder if they mean just 2 months of rent or if they mean that whole period of time, which would cover two different of these time periods,
that's a good point,
as we talked about.
Regardless, the short answer is no, because as I mentioned earlier, in a 3-day pay or quit, you can only go back for a year, unpaid rent for a year. That's all that can be included in the notice. And the 2 dates she's giving me are April of 2020, which is 2 years ago, and March of 2021. Now that may sound like it's in the window, but it's not. It's 2 years out.
Yeah. So small claims court.
Small claims court would be where she wants to go right now.
Yep. Okay.
And by the way, I really encourage, I know, look, the state signed, or the governor signed something into law about 6 months ago that changed the wage garnishment rules to basically rule out wage garnishments as a form of collecting on the vast majority of tenants. But I still encourage you to go to small claims and get these judgments. Put those judgments on these tenants' records. You and I were talking about this, Jeff. There's been hundreds of millions of dollars, if not billions of dollars at this point, of wealth stolen from landlords and transferred over to the tenants. Don't let the tenants walk away from this stuff scot-free just because the state and the city and county, for lack of a better word, I'm paraphrasing, but conspired to do this to you. Don't throw your hands up and walk away. Even if you don't intend or you're unable to collect on that judgment, go get that judgment and let it sit on their record for the next 7 years.
Mm-hmm. Absolutely. And because once you get that judgment, then it's going to show up on their record. It shows up on our eviction report even. Right. And also it gives you something. If you do want a collections agency to go after it, you have that judgment, then they have something to work with. Right. Whether they can find them or not is a whole nother issue. And whether the person has money or not is a whole nother issue.
Well, one other thought on that, you alluded to it, but I'll just clarify a little bit. Look, when you put a judgment on a tenant's record, even a small claims judgment, and the judgment is from ABC Apartments, and the next landlord runs a credit check on that person and they see that on there, they know what that is. So whereas all the eviction records are sealed unless you actually get a judgment, the small claims records are not sealed. So when all of a sudden there's all these judgments popping up on these tenants' records, and it's ABC Apartments, Jeff Fowler, and they contact Jeff and Jeff says, yeah, they were a tenant. That's unpaid rent. Guess what? Now you've got that ability to put that back on their record, what the state took away from you by sealing the eviction records.
And then also we have to remember, isn't there a state law that says you can't deny a renter's application for COVID rent debt?
There is. Yeah. And I apologize. I should have brought that into it. You're not allowed to deny them the tenancy, but the landlords know, right? So look, where would that come into play? all landlords should have written rental criteria. It should be written out. And in the event that tenant, many of the tenants who decided to game this system, it's not their first time to the rodeo. This isn't the first time they've gamed the system. The odds are that they're going to have other things that pop up that do not meet the landlord's written rental criteria, right? So in that event, you're not denying them based on that unpaid rent. You're denying them on a bigger picture. That unpaid rent's showing up. Yeah, that may be true. But if they're not meeting your other criteria, then you're within your rights to deny that applicant.
Now, here's a question that I have. So excuse me, everybody, but it's appropriate for right now. So when you get this information from somebody on the rental application, should you ask them if they have COVID rent debt for the purpose of not discriminating against them if they do?
I would not ask, because
don't ask.
If you ask and then you have that information, let's say you behave entirely appropriately. If you ask and you still deny that person that tenancy, then they're going to turn around and say, well, it was because of the COVID debt. Now you've opened up a box that you're going to have to prove it wasn't. So I wouldn't ask about it. I mean, most of your members are pretty sharp people. They can look at a credit report and put 2 and 2 together.
Right. There you go. Okay. Can an owner file Ellis Act evictions now? And
technically, the answer is no. Well, I apologize. Let me back up. Under the county's moratorium, the answer is no, and until April 1st, right? There's no fault evictions right now. Under the city's moratorium, LA City, they've said, yes, you can do it as of April 1st. So it will all hinge on the county, whether they extend their moratorium or not. If it's in the city of LA and they repeal the moratorium or let it expire March 31st, then yes, as of April 1st, you can go ahead and do that in the city of LA, or I guess everywhere. Right now, the short answer is Ellis Acts are still not permitted.
Okay, Slavika, City of LA, not RSO and exempt from AB 1482.
Okay.
Month-to-month rental.
One lucky woman is all I have to say.
Right? Month-to-month rental agreement. At the end of January, I gave a 30 days notice of the 10% rent increase as well as the security deposit to be twice the monthly rent. The security deposit was due on March 1st, 2023. Tenant completely ignored me. Tenant self-certified within 7 days of hardship due to COVID. What can I do regarding the security deposit?
Well, the security deposit is considered what they call another charge. It's a monetary sum due under the lease. She said it's the city of LA, so their moratorium's technically expired. So she's now under the county's moratorium. They've self-certified. I don't know anything about the level of her asset. You know, if again, it's going to fall back to only low-income people are protected, and it's only if they can demonstrate, all that criteria I walked through before. Mm-hmm. So if they are not low income, they are not protected, she could move forward with an eviction based on that right now.
There you go. All right, Susan, can you file for nuisance when the tenant harassed and broke a neighbor's door?
Yeah, so that's property damage. We talked about that before, right? So it's a threat to the health and safety of the other tenants plus property damage. You could file a nuisance action on that right away.
There you go. Let's see. Okay, Scott on YouTube. My tenant didn't pay January rent, and we agreed to make partial payments for 12 months plus their rent. His last rent increase was last June. Can I give them a rent increase?
Jeff, I'm so sorry. Could you mind backing up a little bit and repeating that question?
Okay, Scott on YouTube. Here we go. My tenant didn't pay January rent.
Got that.
And we agreed to make partial payments for 12 months, plus the regular rent.
Okay.
Okay. His last rent increase was last June. Can I give them a rent increase this coming June?
I have no idea what city his property's in.
Right. So we'll have to assume it's AB 1482.
Yeah. I mean, there's a lot of variables. It's next to impossible for me to answer that question right now.
Yeah.
Apologize.
Okay. Okay. I'm pretty sure the answer is no, but can you give a notice to terminate a tenancy to sell it, properties in Monterey Park?
The answer is no. That's LA. That would be a no-fault eviction, and that is prohibited till April 1st.
Right. Brandon, can you evict for non-payment of rent in the city of LA now?
Who's Brandon? Non-payment of rent, city of LA. This is what we walked through this whole thing. LA's moratorium is expired, so you're under the county's moratorium. County moratorium only protects low-income people who meet that criteria. They have to give you notice within 7 days of the rent being due. They have to prove that they are substantially impacted by COVID, which means that either their income, the household income, went down by 10% over the 12 months immediately preceding COVID, or their household expenses went up by 7.5% by the 12-month period immediately preceding COVID. So
and then we're going to assume that it's exceeding the monetary threshold to evict.
Right.
What papers? Who else do they need to send that 3-day notice to? And what other things? How do they need to serve that person the paper? What papers do they need to serve to make this?
Assuming they're not low income,
right,
and assuming that they've met that threshold, they're just going to serve the named tenants.
Okay, and then who do they need to give that copy to?
Oh, they're going to have to turn that into the city of the housing department. I apologize again. We're venturing off into the city, and right now this webinar was really geared for the county.
Okay,
but I'm glad you asked that question, Jeff. That's absolutely correct. The city of LA, one of their new tenant protections is that every notice that's served essentially has to be turned into the Department of Housing, and you've got 3 days to file it with them. And on some properties, you've got to do that with the summons and complaint, depending on what city your property's in. You have to actually serve the summons and complaint on the city as well. So yeah, I apologize. My brain is on LA County, and we're drifting off into the LA City stuff. Right.
Okay, here we go. Sarkis, can I challenge a tenant's low income status in court? You said yes. Oh,
that's funny. I know Sarkis, and I know why he's asking that question. Yes, if you do not believe that they are low income, the way to do that is through discovery. Take a deposition, make them go through, all the discovery to prove whether they're low income or not. And if they are low income, you're stuck unless you're low income. If you can demonstrate that they are not low income, and they're fighting you on that eviction, then you would prevail. But I happen to know the specific facts of that question. So as it sits right now, our recommendation is to do an additional round of discovery and quite possibly a deposition.
There we go. Okay.
Or wait 2 weeks and hopefully see if this thing expires. And if it does, start over and you won't have to do any of that, Sarkis.
All right, there we go. Claudia, is there a specific lease contract for roommates in the city of Los Angeles?
I'm not sure I understand it. And I think what she's asking for is a roommate addendum. And I'm pretty sure that you guys have one up on your website. So the short answer, if I understood it correctly, the short answer is yes. Go to AOA's website and download it.
There you go. Okay, Garrett, if we haven't been paid for utilities by tenants, which are in our name, in the name of the owner, and we give them the bill, how do we recover those if they haven't been paying?
So as I mentioned before, there's language in these moratoriums that says rent and other charges. So you're basically following the same rules as non-payment of rent. If they're not low income, you could serve a notice of a 3-day cure covenant notice right now, or a warning notice, depending on whether it falls under AB 1482, whatever it is, depending on your jurisdiction and what tenant protection ordinance you might fall under. But again, if they're not low income, you could go after that right now. If they are low income or some reason you have a concern about serving a notice or filing an eviction, theoretically, you could go file a small claims action for that non-payment of the utilities. I will tell you, don't allow them to lapse. Don't shut them off. Don't tell the utility company to shut them off. That you will be subject to penalties and fines and probably the tenant harassment statutes. Now, I want to go back just to clarify one thing I said. I said, go after them theoretically in small claims court, but you still have to follow the same rules. If they're really low income, they're still protected. You wouldn't want to go after them in small claims court for that right now.
Great. There we go. Rosemary, in the city of Long Beach, can I raise rent by more than 10% to purposely institute relocation with fees?
So what do you do? Let's assume for a second you could. And what do you do if you raise it by more than 10% and the tenant says, that's okay, I'll stick around? Your plan was thwarted. But again, right now, I don't believe that you can. Again, we don't know I don't know the facts about the building, whether it's subject to AB 1482, any sort of prohibition by Long Beach, tenant protection ordinance, rent control, anything like that. I just don't know enough facts about that.
Okay. Armando, LA County, Southgate. How am I supposed to repair or remodel a unit if the Board of Supervisors doesn't allow evictions for substantial remodel?
Well, yeah, that's a challenge. So, and that is specifically carved out of that's the no fault evictions that we were talking about. But what I would suggest is if the remodels are the result of health and safety concerns or conditions on the property that amount to health and safety concerns or amount to a situation in which the health and safety of the tenant or the neighboring tenants is in jeopardy, the only way you would be able to approach that is to set it up and start doing it. And if the tenant refuses to allow you access, then it would be based on that denial of entry. But short of that, let's say the tenant does allow you, and I know it's really difficult to do this type of work when the tenant occupies the property. Believe me, I get it. But we're going to have to wait until April 1st to see what happens with this moratorium.
All right. Kimberly on Facebook. If my tenant in Long Beach Section 8 gives me a 60-day notice to leave, but now after 30 days wants to change her mind, can I say no legally?
That's a great question. And to be honest with you, I'd have to look up anything relevant in Long Beach because if there's any sort of and I don't know off the top of my head, I forget now, I've got too many tenants ordinances in my head. Does Long Beach have its own just cause eviction ordinance? I want to say it does. Let me look it up real quick. If it does, then what you would need to know is, hang on a second, let me look. What you would need to know is whether the city allows you to do it for that reason. So, for example, Long Beach does have a tenant protection ordinance in place. So I would need to know, I would need to look that up and see if one of the reasons that allows you to evict is failure to vacate after a lawfully provided notice. So, for example, the city of Los Angeles, that is not one, if it's an RSO property, that is not one of the reasons listed in the RSO, is what we would call illegal holdover. So a tenant can give you a notice to terminate, and if they don't vacate, you can't evict them for that under the RSO. But like I said, there are other ordinances. For example, Tenant Protection Act, AB 1482, it states that if a tenant gives you a notice and they don't vacate, specifically, you're permitted to terminate that tenancy or file the eviction based on their failure to vacate. So I'd have to look at the Long Beach Code and see if that's one of the permissible reasons. I'll give you the code section. It's Long Beach Municipal Code, section 8.99, 21.60, and 21.61. You can look those up on the internet and see if that's one of the available reasons.
There you go. And within the Section 8 contract, is there anything that relates to that?
I didn't even think about the Section 8 contract, to be honest with you. I don't know. Honestly, I don't know that. I've never really, it's very rare you have a Section 8 tenant terminating their own tenancy. But I don't know. I don't want to speculate.
Yeah.
But if I had to speculate, I'd probably completely guess that Section 8 would allow that because Section 8 is not as hardcore as people think, as stringent as people think. They're an ability to terminate a contract with Section 8 is not as difficult as people think. It's the local, tenant protection codes that make it difficult.
All right, here we go on YouTube. George, new 3-day cure violation docs require a witness. Can photos be used as evidence to avoid altercations with possible violence to landlords and witnesses?
So let me clarify what that means. And that's new in some areas. It's not new in other areas. for example, the Los Angeles Rent Stabilization Ordinance has always required witnesses. And what the codes generally say is you have to provide the dates, the times, and the names of the witnesses, and sometimes circumstances that are sufficient enough to allow the tenant to defend themselves, right? So as you can imagine, especially in rent-controlled jurisdictions, a lot of people will claim, oh, this person did that, or this person did that, or a lot of landlords will claim, oh, they're violating the lease, and then they've got no witnesses to back it up. The problem, so that's why the tenant protection ordinances require the names of witnesses. If there was, and the landlord can be a witness. So that's always been there in LA. Yes, now it applies to non-RSO properties in LA because of the new tenant protections that LA passed. It's not difficult to do. You just list the names of the witnesses, like yourself, for example, anybody else. With regard to the pictures, you're not required to attach those pictures to the notice. Those are the pictures you will want to save for the trial, for the eviction itself. So that's not what they mean when they say attach witnesses or anything like that.
And he was wondering about is there anyone who cannot be a witness? Like, can a minor be a witness?
Sure. So you have to be determined to be competent to be a witness. So there are circumstances where a minor could be a witness, could be determined to be competent. In many situations, obviously it depends on the minor's age, right? He's 17 and going to junior college. Yeah, the judge is going to rule he's a competent individual. He's 17, but he has some disability that renders him a 5-year-old mentally. No, he's not competent. Or it was a 5-year-old. No, that individual is not going to be rendered competent to testify. Basically, I believe the test, and now you're going back to law school, but I believe the test is if the person is mentally able to understand the importance of telling the truth and the distinction between the truth and a lie.
Geez, how many people are competent? How many adults are competent?
Yeah, right? Yeah, let's not go down that path.
Yeah. We'll keep it on this here. Okay, Saab on YouTube. I'm planning to give a tenant a 30-day notice to pay the full 1 year past due rent. This is going to come up April 1st. As long as everything goes the way that if everything were to expire the way it's supposed to, is that allowed? And will I be successful in evicting?
Yeah, so I think what he's trying to say is, look, I don't have to give a 30-day notice for some periods of time. It's just a narrow window I have to give a 30-day for, that July through March 31st. But I'm just going to do one 30-day notice for the entire period. And yes, you are allowed to do that. And no judge is going to balk at that because you gave them 27 days more for that other time period than they were entitled to. So no judge or anybody will ever balk at giving them more time than the law requires.
Yeah, and wow, they're planning on it. Here, she also says the tenant hasn't paid rent in the past 3 years. Oh, man.
She must be one of those landlords who was probably pretty confused about, what you could do and couldn't do. And I'm not knocking her. I get it. This has been, you and I've talked about this. The last 3 years have been an insane challenge to try to maintain some of the gray matter up in our head.
Okay, Alejandro on Facebook. I purchased a small duplex in Paramount. I'm moving into the back unit. Front unit has tenants. Can I ask for that unit? I
purchased a duplex in Paramount. Start over.
And so she's going to move into the back unit.
Owner occupied on the back unit. Okay, great. Okay.
Front unit has a tenant.
Front unit's got a tenant, no problem.
Okay, can I ask for that unit? I want to take it off the market. I also want to remodel for family and myself.
Oh, that's a great question. So Paramount, I don't recall if Paramount falls under the city of Los Angeles. I seem to want to say that it does. Maybe not. But under the county's moratorium, I believe she could, as long as the person moving in meets that criteria. And if it were not, let's assume, because she didn't really tell us how old the property is, let's assume it's not under the RSO, but let's assume it falls under this, the city for some reason. I believe under the new tenant protections that she still would, as long as she meets the small mom and pop, exclusion. It's only that question of whether she's under RSO, if she could do that. And she's already got one owner occupied. Candidly, I'd have to look that up. That's a very unique set of facts where it's a duplex and she wants to occupy both. My gut is telling me yes, but again, that's pure speculation, so don't run with it.
Give him a call instead.
Yeah, exactly. Call us.
Okay, on Connie, thank you for your question here. Can rent be increased by 10% for Downey, which is in LA County?
Right now, I do not believe so. Hang on a second. Downey, it's in LA County, but it's not. Some people tell me, oh, my property's in such and such city, but then they tell me, but it's the unincorporated section. So if it's in the unincorporated section of Downey, absolutely not. Let me look Downey up real quick. Let's see. Is Downey incorporated? I believe it is.
Yeah, I think it is.
If I could spell, that'd be great. Yes, Downey is incorporated. So your county of LA, unincorporated, I want to say, let me just check something.
Yeah, Downey's incorporated, right? So.
Yeah, I'm just looking for that repayment. Rent increases, I know we talked about it. April 23rd. Didn't we talk about rent increases? I know we did.
Yeah, we did.
So I apologize. Please bear with me. I just don't want to give bad information.
April 1st, 2023, pass-throughs and increases. You said,
yeah, I want to say that's it.
Yeah.
No fault. I've got a page missing on my thing here. Here we go. Rent increases. Unincorporated LA is April 1st. Pass-through is April 1st. Other cities, yeah, you follow the local one. So in Downey, she can do it.
Yeah. And hey guys, we had those technical difficulties, so thank you. If some of you might see this after the tape's edited, but thank you for being patient with us. And Michael Brennan, he's spent 2 hours here already. If you like Michael Brennan, can you give this video a like, and can you share it? If you know other people who own rental property, please share it with them so that they're just in the know on the things that are going on. And because we're at this 2 hour mark, I just want to ask you how many more questions you could take here, Michael.
I would like to start winding it down. A couple more questions is fine.
Okay.
My brain is starting to get to a point where it needs food and processing slower.
Okay. Man, lots of Section 8 questions today. Okay, Deborah, on Facebook, I have a Section 8 tenant whose lease was up in February. He has applied for a new voucher, and the new apartment he applied for passed inspection. He is telling me he needs his security deposit before he moves out to pay the new landlord. I have no exact move-out date and need to do a final inspection. Not sure how to proceed.
Did she give the city? Maybe I missed it.
She did not.
Okay. So obviously, we don't want to give anybody their security deposit until they've actually moved out and we can do an inspection. It is not uncommon for tenants these days to be in a tight financial spot and actually want to move, be qualified to move, be approved to move, and just not be able to come up with that money. So the first question I would ask is, show me your voucher for the new property, right? You have to have been approved for that new property. The second thing, if I got that voucher, I'd say, okay, now give it to me in writing. Give me an exact date that you want to vacate. The third thing I would ask for is the contact information for the owner of that new property, right? Or the on-site manager. And I would verify that information. And I would say, I want to see, is he really approved or she really approved? Whatever it is, I want to see. And then finally, what I would say is, I would try to work something out with that new owner that says, look, I'm going to do an inspection of the unit. I don't want to release that security deposit until I'm confident that there's nothing beyond ordinary wear and tear. I'm going to set up an inspection with the tenant, and I'm happy to transfer that security deposit right to you as soon as we do that inspection and I get those keys. But he's in a tight spot, but I don't want to release that security deposit. So I would try my best to I guess what I'm trying to say is I would open that door of communication to the new lessor and try to structure it with that person just to make sure everything is legit. The chances are that lessor is going to be more open to working with me about that deposit, especially if I tell him I'm going to give it to you as soon as I look at the unit, make sure there's nothing no damage there. Also, I would say try to set up an inspection with the tenant right away and get that tenant to allow you to take pictures of the unit so that you know what the condition is today versus the day they give you the keys back. That's a difficult situation to navigate, but it can probably be done, especially if she really wants the tenant to vacate. There might be a reason she wants the tenant to vacate. I would try to do what I could to facilitate it with the new owner or the new landlord.
Okay, great. And here we'll take this one last question, Julietta. Building in LA under RSO, we have made payment plans for residents who have high balances with us. If the resident does not follow the agreement, can we evict them?
Man, I know. I'm not a blank, but I can't figure out if it was in the county's moratorium or in the city's last iteration. There was one that specifically said you cannot evict people for their failure to comply with a payment agreement. And I want to say that was the city of Los Angeles's, but I'll have to double check that. I look, it's very unlikely that you're going to be able to evict for the failure to pay a payment plan on COVID debt, unless that moratorium is completely expired, all the payment protections are gone. But like I said, I know that provision is in there. I just can't recall if it's in the counties or the cities. I think it's in the cities.
Hey, you guys, you have to meet Michael Brennan face to face at the LA Convention Center on April 19th. Michael Brennan's going to be speaking, as well as he'll have a booth there. And anyway, so definitely stop by his booth and definitely check out if you go to AOAUSA.com, you can click on more information about the $1 Million Trade Show, and you'll love it. So definitely ask him questions there. You have his phone number. You have the email address there, mbrennanlaw.com. So you can write a question in there and they'll get back to you. And Michael, thank you so much for all of your time. Really appreciate it.
You're very welcome. Thank you for inviting me to speak again. I appreciate it, Jeff.
Yeah, absolutely. And thank you guys. We'll see you next time. All right. Take care.
Bye.